Mr. Ojwang,
Present.
Mr. Lagat. There are two Lagats.
My name is Philip Lagat.
Philip Lagat.
Oh, Philip. You're not present the last time, or you're present?
I was not present.
Okay.
He was in the quorum.
Okay.
We had sent him to do another matter as well. Mr. Kangai, present. Mr. Shadrach Wamboy,
Good afternoon, Madam President.
Good afternoon.
Mr. Stanley Kunajui,
President, Your Honor.
Mr. Geoffrey Lagat. There are two Lagats.
Present, Your Honor. Present.
Mr. Keaton Philip.
Present, Your Honor. Felix. Yes, present, Your Honor.
And Mr. Vincent Yegon. That's the team for the transport.
All right, thank you.
And before you read the ruling,
Yes.
there is a preliminary issue that we wanted to put to the court.
So, Council, let me deliver the ruling, and then
It is very important so that the court understands. It's only 2 minutes. Only 2 minutes. We are not making an application to arrest the ruling. It is just a small concern.
it's okay. Yes,
Thank
any Mr.
We understand the defense to be asking you to arrest the ruling.
No.
If not, then we proceed with the ruling, then they can make the application.
Yes, if he
The only way to
doesn't.
stop the ruling will be to arrest it.
No, we are not
Then
arresting. We are
proceed
not
with the
stopping
ruling.
it.
We'll be waiting for them to.
We are not stopping it. It has nothing to do. Probably we are saying we have conceded 21 days. Allow us only to, we'll take 2 minutes.
You know, with a lot of respect, we would urge the court to read the ruling, which is the business of the day. Once we're done with the ruling, we can deal with any other matters arising therefrom or related thereto. But the court can give it.
So, Council, since you've indicated quite clearly that it has no bearing with the ruling, I'll proceed and deliver the ruling.
But
Okay. So the contextual milieu of what this court is making a determination is in respect to a miscellaneous application seeking the respondent pre-charge detention. There is no criminal trial yet. This follows the abominable, macabre murder of a teacher and blogger, Albert Omondi Ojwang, hereinafter the decease, that took place on the 8th day of June 2025, allegedly at the Central Police Station, Nairobi. While coming up with this ruling, a stone's throw away from here, this country was confronted with execrable and reprehensible sins following the Margot protests that took place yesterday on the 17th day of June 2025, paradoxically, to condemn the murder of the deceased. I point out and I shudder for my fatherland, and if I can borrow from William Shakespeare's poem, The Rape of Lucrece, I'm terribly in terror following the degeneration of lawlessness that was witnessed yesterday. I fervently take this opportunity to remind my beloved countrymen of the Israel World Holocaust Remembrance Center and the Kigali Genocide Memorial. Let us all collectively proclaim never again. Now to the body of the application. So the applicant, by way of notice of motion dated the 16th day of June 2025, has moved this court under the provisions of Article 49, Sub-Article 1, Paragraph F, G and H of the Constitution, Section 36, uppercase A of the Criminal Procedure Code, Section 6A, 71A and G of the Independent Policing Oversight Authority Act, and Regulation 7, Sub-Regulation 4 of the Independent Policing Oversight Authority General Regulations 2024, and all the enabling provisions of the law. The applicant now seeks to have this court have the respondent to be remanded in Langata Police Station or any other police station within the Republic of Kenya as the investigation may dictate, to enable the applicant conclude investigation for a period of 21 days. The other prayer seeking to have the respondent's gadgets seized and subjected to forensic examination was conceded to. The applicant has on the face of the motion explicated the following grounds in support of the prayers. A, that the applicant is conducting investigation via inquiry number Ipoa /INV /476/2025 into the gruesome murder of the deceased that is suspected to have occurred at the Central Police Station, Nairobi, where the deceased was being detained. B, that the respondent was arrested on the 30th day of June 2025 by the DCI officers and subsequently handed over to Ipoa and was later booked at Langata Police Station via OB number 50 of 13th day of June 2025 at 18:05 hours. C, that at the time of the respondent's arrest, he was duly informed the reason of his arrest, which is the ongoing investigation on the gruesome murder of the deceased. That brief evidence gathered so far, the respondent and others still at large are suspected to have directed, planned, and attempted cover-up of the brutal fatal assault of the deceased while inside the cells at the Central Police Station, Nairobi. E, that at the time of the respondents, his mobile phones were seized and are yet to be subjected to forensic examination. F, that from the time the respondent was arrested, the time within which to complete investigation has not been adequate, and there is need for extension of time to enable completion of investigation. That based on the ongoing investigation, the applicant requires additional 21 days within which to complete investigation, and that the respondent be detained at the aforementioned police station. The application is supported by the affidavit sworn by Abdirahman Jibril, a Senior Assistant Director of Investigation with the Independent Policing Oversight Authority. From here, after I'll refer to as Ipoa, on the 16th day of June 2025. He deposes inter alia that preliminary investigation by Ipoa has revealed that on the 4th day of June 2025, the Directorate of Criminal Investigation received a complaint from the Deputy Inspector General of Police, Mr. Lagat, alleging that he suffered continued false and malicious publication on an X account, formerly Twitter, with the name Pixel Pioneer, and requested investigation as to the perpetrators. He contended that following investigation, it was established that the deceased, a resident of Lira Center within Homa Bay County, was identified as a person of interest. He further avowed that the deceased was arrested and escorted to Nairobi, where he was booked at Central Police Station via OB number 136 of the 7th day of June 2025 at 9:32 p.m. while appearing normal. He also deposed that at the material time, the respondent was the officer commanding police station, exercising command over the Central Police Division, thereby wielding immense powers with the capacity of interfering with the ongoing investigation and witnesses. He attested that the respondent is the custodian of the station records and the surveillance system which he is likely to interfere, and further that the respondent and the co-conspirator allegedly hired a technician to interfere with the CCTV system at the station in a bid to tamper and interfere with the investigation. He asserted that on the night of 8th June 2025, the deceased was found unresponsive in a pool of blood inside the cell and was taken to Bagathi Hospital, where he was confirmed already dead, and subsequently a postmortem revealed that the cause of death was head injury due to blunt force trauma, neck compression, and multiple subcutaneous bruises all over his body. He contended that the respondent with other persons at the station were instructed He contended that the respondent with other persons at the station were instructed and caused to make false entries in the police records with a view of misleading the investigations. He further averred that the respondent was in constant communication with one James Muhwana, the cell sentry personnel on duty, and who had access to the cells where the deceased was detained. He also contended that the respondent has had constant communication with people within and outside Central Police Station immediately before, during, and after the commission of the crime, and therefore suspected to have planned the brutal assault of the deceased. He contended that the release of the respondent will jeopardize the arrest of his accomplices involved in this gruesome murder, including witness interference, who are under the command of the respondent. He urged that the key figures targeted in this investigation are police officers who wield powers and influence and have engaged in a complex web of cover-up employing the blue code of silence. Thus, the need to detain the respondent to impede interference with investigations and witnesses. It was also his consternation that the murder of the deceased has elicited widespread public anger and outrage, resulting to demonstration as a consequence, the safety and security of the respondent cannot be guaranteed if released. In summation, he avowed that considering the seriousness of the offense, there is a temptation of the respondent fleeing the jurisdiction of this country, and therefore he is a flight risk. The application has been strenuously and vivaciously backed by a battery of indefatigable counsel representing the respondents. They are, in order of seniority, Mr. Dunstan Omari, Mr. Cliff Ombeta, Mr. Shadrack Wamboi, Mr. Kangai, Mr. Stanley Kinyanjui, Mr. Udoto, Mr. Lagat, Mr. Keaton, and Ms. Sophia Nekesa. I hope I have not left anyone out. Conversely, the applicant is represented by the lettered and studious counsel, Ms. Nora, Mr. Owiti, Ms. Makuri, and Ms. Christine Owino represent the Ipoa, and the family is represented by the learned counsel, Mr. Julius Juma. During cross-examination by the respondent's counsel, the irascible deponent affirmed that Ipoa has the powers to investigate deaths in the custody of police officers. He stated that the respondent recorded a statement upon his arrest. He confirmed that the respondent voluntarily presented himself at the DCI headquarters and that it was untrue that he was arrested in Eldoret. He admitted that he has not averred that the respondent was on duty at the material time. He also iterated that the scene is the Central Police Station, Nairobi, which has already been processed by Ipoa. He affirmed that they are yet to record statement from certain critical witnesses, some of whom are police officers. He conceded that he has not provided several evidentiary material in support of his deposition so as not to compromise with the investigation. So additionally, the application was conversed orally. It will be remiss not to applaud the counsel for their punctiliar, industry and erudite submission. I have carefully and conscientiously considered the oral representations of the parties' advocates, the constitutional and statutory authorities cited, as well as decisional law quoted in extenso. The jurisprudential underpinning on pre-charge detention, or what the Constitution in Article 49, Sub-Article 1, Paragraph G delineate as detention continuing, as aptly pointed out by the learned counsel, Mr. Owiti, is now well settled. I am grateful to the learned counsel, Mr. Ombeta, Mr. Keaton et al., in having a footprint in the development of the law in this realm, in some of the authorities that the Superior Court which has been cited herein. Mr. Owiti, learned counsel on behalf of the applicant, has anchored the application on Article 24, 25, 29, 49 of the Constitution and Section 36, uppercase A of the Criminal Procedure Code, as well as Section 8, subsection 2 of the Magistrate Court Act, and the seminal and the well-crafted and the grandiloquent decision in the case of Sudi Oscar Kipchumba versus Republic 2020 EKLR. He made reference to paragraph 24 of the ruling, where the learned Professor Ngugi J, as he was then held, open quote, So even while accepting the text of Article 49(1)(f), may in certain circumstance and context comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reason for his continued detention through the state's application to have him so held, the state must satisfy the double test. First, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without charge, being preferred whether provisional or otherwise, is inevitable due to existing exceptional circumstances. The second test is the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interests present in a potential criminal trial, the rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice, and the interests of the victims of crime where appropriate. By virtue of Article 21(1) and 259 of the Constitution, the court must act to aggrandize, not to diminish, the personal liberties of arrested individuals in line with the other three interests. Differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by this quadruple interest and without reifying or essentializing any. End of quote. Flowing from the foregoing, he submitted that the respondent was duly informed of the reason for his detention and the state has acted in absolute good faith in timelessly presenting the respondent before court, and furthermore, that they have demonstrated that the balancing of the rights of the respondent vis-a-vis the victim, the interests of justice, public order, peace, security, and the integrity of the administration of justice. The Learned Counsel, Father Mr. Whitty, in rejoinder to the submission, has appealed to the court to take public notoriety as to the seriousness of this offense. He ingeminated that the respondent, being the officer commanding station of the station, has immense influence on witnesses and investigation. Mr. Whitty elucidated the phenomenon coined as the Blue Code of Silence by citing the Court of Appeal decision of Titus Gamao Musila Katitu versus Republic 2020 EKLR, where counsel submitted that the court demonstrated and observed that the police officer in Kenya have in certain circumstances engaged in the practice of collective covering up for each other for purposes of self-preservation, patently in a murder investigation like the instant case. On his part, Mr. Makori, Learned Counsel, elucidated and annotated the averments in the supporting affidavit, emphasizing on the possibility of the respondent interfering with witnesses and investigation as the officer commanding the Central Police Station. He entreated the court to grant the 21 days detention continuing order sought. Mr. Kitot, Learned Counsel for the respondent, made resplendent and methodical submission. He urged in general that the applicant have not demonstrated compelling reasons necessitating the continued detention of the respondent. He cited Article 49, Sub-Article 1, G and H of the Constitution and Section 36A3D of the Criminal Procedure Code. He urged that there are no cogent and demonstrable ground that the respondent will interfere with the investigation. He also cited the case of Republic versus Mercy Chebet and also the case of Republic versus William Chirchir and another, where he submitted that the superior courts held that there must be cogent material before court to demonstrate actual or perceived interference with witnesses by the respondents, which was lacking in the instant case. Mr. Keaton further urged that in limiting the fundamental freedom of a suspect, courts ought to be extra vigilant in granting such orders. He referred to the case of Ramadan M. Hassan versus DPP 2017 EKLR. He proffered further that the respondent has all along cooperated with the investigation. He reverberated that the respondent voluntarily presented himself to Ipoa, where he recorded a statement and later presented himself to the DCI headquarters. He told the court that the respondent has since been interdicted and therefore has lost police powers to interfere with the witnesses. Furthermore, his interdiction has set condition that he should periodically report to the Eldoret police station. He urged the court to issue order that will be beneficial and less restrictive to the respondent. He made reference to the often cited case of Michael Rotich versus Republic by Justice Kimaru as he was then, 2016 EKLR, where the court stressed the need to protect and preserve and respect the right to liberty. Learned counsel adjured that the accused is not a flight risk. He submitted that he has a fixed abode both here in Nairobi and in Eldoret, and also that the respondent should be accorded the presumption of innocence. Finally, he urged the court to adopt the tests of determining compelling reason as set out in the case of Republic versus Danford Kabage Mwangi, 2016 EKLR. He thus exhorted that the application should be declined. Mr. Lagat, learned counsel, also for the respondent, iterated that there is no evidence of interference of investigation, since the deponent confirmed that, and the investigating officer confirmed that they are in possession of the respondent's mobile phone, in which the respondent has control in regards to the forensic analysis. He submitted that the respondent is willing and ready to abide by all the conditions that the court will set. So that we can, but I haven't heard from the for the victim. You've been mum today, eh?
Thank you,
Yeah.
Your Honor.
Yes.
I also did very well in the
Okay.
I won't say what that's called.
A levels or O levels?
Your Honor, it would only make sense to compute the number of days that you are granting the investigators from the date they came to you. Because when they came to you, they said, we have done 49%, and we need 21 days to do 51%. So you are telling them that 21 days is a bit on the higher side, but I can give you 15. So the 15 is to do the 51%.
Yes.
So it should be computed from the date they had not done the 51%. That is 16%.
Okay. Thank you.
And Your Honor, just to add on one thing,
Yes, Mr. Kito.
even as you grant us the specific time and compute, remember we'll still have a mention so that they can come and report to the Honorable Court, so that if there are some areas that they need to cover, they will still make another application, so there's no prejudice whatsoever from their side. We'll still come back for mention, and if you have concluded the investigation, we shall deal with the next process, but if it's not, we will make that application also.
Your Honor, with your kind permission, just to be fair,
Ladies first, eh?
Thank you, Your Honor. Just to be fair to the investigator,
Yeah.
he's not here at the moment, but being a counsel at Ipoa, I can confirm concretely that on that 16th is when we were computing the 49%.
Okay.
Yeah, so as far as we are concerned, bringing that application to you, the 21 days was to count from that day onwards.
Okay.
And therefore, with your ruling now, it should actually count from that day.
Okay.
The 49% from the 16th day when the application will be filed.
Okay. Mr.
Your
Shadra?
Honor, if you permit me. Your Honor, I think there are some little oversights being made by my senior, Mr. Witty and Mr. Julius Juma. They make the argument with the assumption that the ruling has been made on the 16th. When the ruling has been made, just watching, okay, we are common law lawyers, so we can take that. So, Your Honor, flowing from the arguments that have been made by my seniors, I think that as we speak already, they have already spent 2 days. Because we came here on the 16th, they have already spent the 2 days. So it doesn't make sense for them now again to make the arguments that you should be looking at things from the 49 based on when they came to you. They have already been doing some certain things. So from that, Your Honor, I beg that I be associated fully and extensively with the arguments made by my seniors and my colleague, Mr. Kiaton.
No, we actually agree with Mr. Wambui, only that is, in conclusion, is agreeing with the other side. We are telling you not to count from today.
Yes.
Please count from 16th. 2 days have gone.
Yeah.
Those 2 days take them away from the 15th.
So I'll give direction.
The court
Just before the directions, Your Honor.
Yeah, thank you.
One thing.
Yes,
Your
Mr.
Honor.
Lagat.
They're also not telling us the number of days they need to get 49%. If you use 6 days,
Let's avoid the back and forth.
Give direction.
That issue
Okay, I wanted let me just give direction, but there's something I want to quote here from Kizito Mihingo in his book The Meaning of Death. Yeah, Kizito Mihingo, for those who vastly read, yeah, is a Rwandese songwriter. Yeah, and he quotes, yeah, "There's no such thing as a good death, be it by genocide or war, slaughtered in revenge, vanished in an accident or by illness. Those loved ones are praying for us. There is no worse thing than death." End of quote. So the direction I'll give, maybe this is the last time I'm in contact with this matter because I believe probably investigation will have been concluded and the matter advanced. I sincerely send my condolences to the family of the late teacher and blogger Albert Omondi Ojwang. So kindly, Julius Juma Council, convey the court's deepest sympathies, yeah, and condolences. So in respect to this issue of computation of time, the same will be computed from the 16th of June when the application was filed and lodged before this court. So those who are quick in maths, it takes us to the 1st of July.
Yeah, 1st of July, that's right.
Mr. Dunstan?
Yeah, then
Yes.
I'll do the next application.
Okay.
One
So we've agreed we'll have a mention on the 1st of July. Yes, you can proceed with your...
You know, defense conceded to prayer 2
Okay.
and granted access of the phone to Ipoa. The handset was taken by the investigator on the date of arrest. Other than the investigator and the owner of the phone, none has access to the operation of that phone. From yesterday, that same number of the OCS, it is number, that same number, Your Honor, the OCS, that is the respondent, 0722 91 9880, has been sending messages soliciting for money. Among the victims is Mr. Cliff Mbeta, who has been asked for 80,000 shillings. Family members who are here, the phone is engaged in looking for money and fundraising that the OCS is in a problem that he requires money, people to fundraise for him. This is a serious issue that if the commissioners of Ipoa, who are in custody of the handset and the password, have allowed that phone and that contact for citizens to be swindled, it is so serious, and we shall be seeking that the custodian of those funds, those are the commissioners of Ipoa, be summoned to this court to explain how the phone in their custody can be used to defraud Kenyans. You know, remember, it was a spirited fight to get the access, and we said we have no problem. Ipoa is a constitutional office. But definitely, that is where we are saying, if the state is disputing, we want the commissioners to be present before this court to explain that grievous anomaly. You know, with that, I will allow my other colleagues to proceed. I have another matter before Machakos High Court at 4:30. so that I go and attend,
Okay.
I be allowed to be disturbed.
Okay, you
But
bet-
my
you excuse.
able team is able to prosecute that matter.
All right, thank you.
Thank you.
You wanna to buttress on that? Our client reported to Langata Police Station
Yes.
by OB dated 18th of June 2025, whereby he reported all those issues.
Yes, sir.
And what we pray, Your Honor, apart from the summons, is expedited investigations so as to protect the integrity of the investigation. Because it goes into the root of all this process. If that phone, gadget, and everything is infiltrated, Your Honor, the integrity of investigations will be jeopardized. And as such, Your Honor, pursuant to that OB and that report, we pray that the investigations be expedited, the investigating officer be summoned to explain, and also on top of those commissioners, Your Honor. We so pray.
Your Honor, from my side,
Yes.
probably be a witness in this matter at the end of the day, in case we arrest.
Oh, you
this,
received a
Ipoa.
message also?
Yes, I'm the one who received it
Okay,
actually.
okay.
And that was,
Okay.
but one was to me at about 9 p.m. in the night.
Okay.
Probably I might be a witness eventually if we arrest these Ipoa people, but then for the moment, just like everybody is stepping aside, if the Ipoa can step aside until we sort of this issue. And it's serious.
Just before Mr. Witi, my colleague also mentioned the aspect of the integrity of that gadget. That gadget is a subject of investigations by. The moment they are able to use that gadget for other purposes, we don't know what they are doing with it. That may result in an outcome that none of us is in control.
Indeed.
And even the court, whatever the outcome of that investigation, nobody can assure us of the integrity.
So, Your Honor, perhaps